Dr. Justice D.Y. Chandrachud, Honorable Chief Justice of India, Justice Hilary Charlesworth, Honorable Judge, International Court of Justice, my esteemed brother and sister judges of the Supreme Court of India, Honorable former Chief Justice of India, Honorable former judges of the Supreme Court of India, Chief Justices and judges of the High Courts, distinguished ambassador and officers of the Australian High Commission, learned Attorney General for India, Dr. R. Venkatramani, learned Solicitor General of India, Mr. Tushar Mehta, chairpersons of various national tribunals, law officers of the Government of India, President Dr. Adish Agrawala, other office bearers and members of the Supreme Court Bar Association, a very distinguished team of senior advocates from the Supreme Court of India, esteemed audience who have joined us both in person and via virtual mode, ladies and gentlemen, I wish you all a very pleasant morning. It is my proud privilege to welcome you all to the second Supreme Court of India annual lecture series, which was initiated the preceding year. The objective behind the commencement of this series was imbued with twofold purpose. A, to commemorate the founding of the Supreme Court of India, and B, to cultivate a rich exchange of ideas between the Indian judiciary and our colleagues abroad. It aims to be a collaborative platform dedicated to the advancement of constitutional values. The first edition of this annual lecture series was graced by the presence of Chief Justice Sundaresh Menon from the Supreme Court of Singapore, who delivered an indelible lecture on the role of the judiciary in a changing world. I wish to apprise our distinguished guests from abroad that the Supreme Court of India first opened its majestic doors on 28th January 1950, just 2 days after the Constitution of India came into force on 26th January 1950. Since its very inception, the Apex Court has played a pivotal role in upholding the rule of law as a repository of ensuring justice for all and as a guardian of the constitutional morality. On the momentous occasion of this year's annual lecture, we are delighted to welcome Justice Hilary Charlesworth, Judge, International Court of Justice. On behalf of the Supreme Court of India, I extend my heartfelt gratitude to Justice Charlesworth for graciously accepting our invitation despite your many demanding commitments. We are beholden to you for your august presence. Thank you, ma'am. Justice Charlesworth, adorned with a career marked by scholarly excellence and judicial dexterity, stands as a luminary figure in the realm of jurisprudence. She is a distinguished alumnus of the prestigious University of Melbourne and Harvard Law School, having attained her doctorate of juridical science from the latter. She is also a Fulbright scholar. Justice Charlesworth was decorated with the title of Laureate Professor at Melbourne University Law School and has also taught law at the Australian National University and the University of Adelaide, among numerous other prominent institutions. I would like to add here that Justice Charlesworth is no stranger to India, and this event is rather akin to homecoming for her, as she previously taught at the Mayo College, Ajmer in the year 1976. We all welcome you heartily. It is noteworthy to mention that after qualifying professionally as a barrister and solicitor of the High Court of Australia, Justice Charlesworth was admitted to the bar at the Supreme Court of Victoria in 1981. While I have known of Justice Charlesworth's exalted work in international law, from a judicial standpoint, what truly amazed me was the breadth and depth of her impact on jurisprudence through an extensive array of academic works. Her prolific output, encompassing numerous books, publications, articles, and even encyclopedias, are testimonies to her unparalleled dedication to advancing legal scholarship and shaping global legal principles. Her book, which she co-authored, titled The Boundaries of International Law, a Feminist Analysis, was awarded with the Certificate of Merit by the American Society of International Law. We are surely fortunate to have such an eminent legal luminary with us today. Justice Charlesworth, since assuming her position on the International Court of Justice in 2021, has continued her illustrious journey underscored by remarkable achievements. Upon her election to the ICJ, Harvard Law School professor David W. Kennedy, who first met Justice Charlesworth during her graduate studies, said, and I quote, "Hilary Charlesworth is one of the most innovative international lawyers and original voices in the field of international law in the last generation." I express my deep admiration for Justice Charlesworth's remarkable contributions to the legal landscape, particularly in her involvement as an ad hoc judge in the ICJ in pivotal cases such as Guyana versus Venezuela, which centered on an arbitral award, and the notable whaling case Australia versus Japan. Justice Charlesworth's contribution in the field of international law have also earned her widespread acclaim. Her erudition and expertise have illuminated countless legal debates and enriched the global discourse on matters of utmost significance. As one of the select few women to be elected as a permanent judge in the ICJ's 78-year-old history, the presence of Justice Charlesworth in the International Court of Justice heralds a new era characterized by inclusivity and diversity. Furthermore, Justice Charlesworth has admirably assumed the role of a great mentor to numerous aspiring professionals and scholars within the sphere of international law, notably prioritizing support for women. Her dedication to fostering the next generation of legal minds exemplifies her commitment to diversity and empowerment within the legal community. The audience will be delighted to know that our own Chief Justice of India, Dr. D.Y. Chandrachud, and Justice Charlesworth pursued their doctorate degrees in the same years at the Harvard Law School. It's a pleasure to have these two internationally renowned jurists grace this dais together. This year, on the 28th of January, the Supreme Court of India marked the beginning of its Diamond Jubilee year and stands poised at the threshold of a new age characterized by heightened collaborations with judicial counterparts from across the globe. This concerted effort is aimed at not only disseminating our cherished values but also encouraging a meaningful exchange of best practices. By engaging in fruitful dialogue and forging long-term partnerships, the Supreme Court of India endeavors to nurture a shared understanding while embracing the varied perspectives that embellish our collective pursuit of justice. The commitment of Supreme Court of India to prioritize the rule of law and value the significance of human rights needs no emphasis. The Apex Court has consistently demonstrated a nuanced understanding of global progress in the human rights discourse and legal frameworks, and has not only upheld the tenets of the Indian Constitution but also enhanced the broader international conversation on justice and rights. Its judicial pronouncements resonate universally, impacting judicial doctrines and acknowledging emerging rights across jurisdictions. Today's lecture marks a continuation of Supreme Court of India's steadfast determination to initiating global dialogues on justice. Through the invitation extended to distinguished jurists from around the world, we aspire to facilitate open and candid discussions on various issues confronting our justice systems. We are eagerly anticipating Justice Charlesworth's illuminating insights as she delves into the topic, the International Court of Justice, a legal form in a political environment. As we know, the International Court of Justice, being the principal judicial autonomous organ of the United Nations, is a promising platform for the nation states to seek redress and uphold the rule of law on the global stage. The International Court faces unique challenges in upholding its judicial independence and impartiality in the constantly evolving political arena. How this court manages to sail through troubled waters is quite interesting. The words of wisdom of Justice Charlesworth will surely make us understand how they untangle the inner knots of these intricacies. With her extensive experience as a judge of ICJ and her proficiency in international law, both as an academic scholar and a jurist, we look forward to gleaning invaluable overview that will undoubtedly enhance our understanding and refine our thoughts on this pertinent subject matter. With these few words, I once again thanks and convey a very welcome to each and every one of you to this great event. Thank you very much.
Thank you, sir. I would now like to call upon Dr. Justice D.Y. Chandrachud, Chief Justice of India, to kindly share his thoughts with us.
A very distinguished guest and speaker for today, Justice Hilary Charlesworth, Judge of the International Court of Justice, my colleagues, Judges of the Supreme Court of India, former Chief Justices of India, former Judges of the Supreme Court of India who have enhanced the dignity of this function by gracing this occasion, Chief Justices of the High Courts, the Attorney General for India, the Solicitor General of India, Mr. Venkatramani and Mr. Tushar Mehta respectively, President and Secretary of the Supreme Court Bar Association and of the Supreme Court's Advocates on Record Association, Senior Counsel. I was just telling Justice Charlesworth that we have more women senior advocates who have been designated in one lot than we had over 75 years of our history. Distinguished guests, members of the bar, and all the invitees here. First and foremost, I must share a little secret with the over 600 plus audience that we have this morning. Thank you all of you for joining us. But the secret I want to share with you is that we have a birthday boy in our midst. Happy birthday to Justice Suryakant. It is indeed a moment of honor for me to join Brother Justice Suryakant and all of you in welcoming to the Supreme Court Justice Hilary Charlesworth, a judge of the International Court of Justice, an esteemed scholar, a pioneering feminist thinker, and most importantly, a dear old friend. Now, I have in my text of the speech put old into inverted commas for the simple reason that what I say about Hilary applies to me in equal measure as well. And I'm not prepared as yet to accept that the phrase applies to me. But when I say dear old friend, I really mean that we go back a long way in time. Judge Hilary Charlesworth and I forged a strong and enduring bond throughout our academic journey at Harvard Law School, where we were students for the LLM class of 1983 and pursued our doctoral studies leading up to the SJD together. We both completed our Doctor of Juridical Science in 1986. We discovered common interests and values that solidified our friendship. We attended classes and seminars together, engaging in meaningful conversations about law and philosophy. Our friendship extended beyond the classroom as we spent our formative years discovering Cambridge. Harvard Law School's academic rigor posed a formidable challenge, yet our friendship provided invaluable support easing the journey as we navigated through the demanding curriculum. On a lighter vein, there is a quote by Charles Morgan, a British playwright, that I often think about when I look back at my days at Harvard Law School. And Charles Morgan said, if Moses had gone to Harvard Law School and spent years working on the Hill, he would have written the 10 Commandments with 3 exceptions and a savings clause. In a movie which is based on Harvard, which is very close to my heart, I've watched it several times, called The Paper Chase. The last scene of The Paper Chase is when these graduating students at Harvard Law School make paper rockets out of their marks sheets, the degree certificates, and then let them into the wind to flow into the breeze. I think I never realized the importance of that until I was reflecting on it again this morning. And I believe what it really tells us is that in this great equalizer of life and the profession, our birthmarks are surely erased, at least over time. Hilary attended, like me, Lawrence Tribe's course in constitutional law, and she was the only person in the class who got an A+ from Lawrence Tribe. Tribe became her supervisor for the SJD. As students of the SJD program, we had the best perquisite available on display at Harvard, which was we had offices of our own, all overlooking the beautiful greens. We also played our own version of the Davis Cup together at Harvard Law School. We had, as Hilary always said, a team comprising of players from Australia, India, Ethiopia, and New Zealand. But the standout image that remains etched in my memory is of Hilary on a bicycle with a little attachment to carry the groceries or to put the day's, we didn't have laptops in those days, but to put the day's working material. That reminds me always that truly, Hilary wears her scholarship and erudition with a badge of simplicity. That's truly the sign of a great human being. I have pleasure in welcoming her spouse, Dr. Charlie Guest, as well. And before I move on to a little more formal a part of my speech, I must conclude the first part, the more personal part, which is a little anecdote, which I am sure you'd forgive me for sharing on a personal note. Hilary has 2 children, Stephanie, Steph, and Will. And Will was extremely, and still is, very fond of cricket. So when the Indian cricket team went to Australia, she took special permission from the Indian High Commissioner so that little Will could go and meet the Indian cricket team at the reception for which she was invited. And a couple of days later, Hilary spoke to me and said, there's something very interesting that happened. And he just refused to go and brush. That night, when I told him as a young child, you have to go and brush and then be done for the day. And he refused to brush. So I asked him, why aren't you brushing? So he had met Sachin Tendulkar and shook hands with him. He says, you don't brush and wet your hands after you have spoken to God and shaken hands with God. Well, so much for a few personal things. Last year, to celebrate the legacy of the Supreme Court, we instituted an annual lecture commemorating the momentous occasion of its first sitting on 28 January 1950. For the first edition, we were honored to host Justice Sundaresh Menon, the Chief Justice of the Supreme Court of Singapore. This year marks a special year. It is a momentous occasion in the history of the Supreme Court and our nation. The Supreme Court of India has entered the 75th year of its inception. No one better than a judge and a scholar with years of experience and a profound understanding of the law could aptly capture the significance of this milestone. Thank you for graciously accepting our invitation, Justice Charlesworth. At Harvard, Justice Charlesworth worked on her dissertation on constitutional law from the North American and Australian perspective, while I labored over my work on affirmative action in India in the context of comparative law and jurisprudence. As we both toiled over our dissertations, we engaged with the law, but were also compelled to navigate the dichotomous yet intricate relationship between the law and politics. The theme Judge Charlesworth has selected for our lecture today, International Court of Justice, a legal forum in a political environment, is to say the least interesting and topical. It is, of course, of contemporary relevance in view of the unprecedented growth in the docket of contentious cases before the International Court of Justice. Notably, however, the theme for today's lecture also reflects a question that is fundamental to the law and legal systems, both domestic and international. The International Court of Justice held its opening session on 18 April 1946, a time when approximately a third of the world's population, including Indians, lived under colonial rule or in non-self-governing territories. As the International Court of Justice celebrated 75 years of its inception in 2021, its then President, Joan Donoghue, recognized that there has been a significant change in the composition of the court since its inception, which has impacted the functioning of the court and the diversity of cases which it is called upon to adjudicate. Today, there are 193 United Nations member states. The existence of a diverse member states community has had a tangible influence in the kind of cases that the ICJ is faced with today. It no longer deals with only questions of convention or border disputes or whaling. Not only has there been an increase in the number of cases brought before the court, the subject matter of the cases has also seen a sea change. Various nations are calling on the court to determine issues of human rights, including questions about the Genocide Convention, as we saw recently, and the Convention on Torture. In this way, the change in global politics has been crucial in shaping the transformation of the ICJ as well. It reflects the deep interplay between politics, power, and the law. Similarly, the institution of the Supreme Court of India in 1950, which we have gathered to commemorate, was also a moment that marked political and social transformation. It cannot be viewed, our founding moment cannot be viewed as divorced from the political realities of its time. The sitting of the Supreme Court for the first time echoed the aspirations of a nascent country, burdened by the legacy of colonial rule and entrenched social stratification, yet equipped with a transformative, progressive, and foresighted constitution. Over the years, the Supreme Court has embodied these aspirations by crafting a vast body of jurisprudence aimed at liberating India from its colonial past and fostering the groundwork for social transformation. In this journey, the apex court of the nation has emerged as a product of the interplay between the polity, societal aspirations, and the law. At this moment, it is important to emphasize that diversity and representation is crucial not only for rectifying historical injustices, but also for enriching the decision-making capacity of our courts. The evolving representation of nation-states before the ICJ has notably challenged its historically monocultural and Eurocentric outlook. Likewise, integrating gender diversity within the courts would substantially broaden the spectrum of perspectives, leading to more comprehensive and equitable decisions. In her book, Boundaries of the Law, Justice Charlesworth notes that in 1999, when she completed writing the first edition, international law was in a period of renaissance that was marked by the end of the Cold War between the West and the Soviet bloc, the dismantling of the Berlin Wall in 1989, which appeared to have freed international law from its political shackles. The United Nations Security Council had begun to create new institutions and adopt new thematic agendas, such as the protection of civilians and children in armed conflict. Yet, there are times that the new world order, as she tells us, may not necessarily improve the lives of women. And she says, widespread violence against civilians, including violence targeting women and girls, accompanied the new wars and ethno-nationalisms in, among others, Somalia, Rwanda, Haiti, and the Balkans. The rise in the trafficking in women and girls with opening of borders between Eastern and Western Europe, she says, and the deployment of peacekeeping troops, the increasing prominence of fundamentalist religious groups, commitment to neoliberal economic ordering, and inequalities and violence accompanying the free market zones were other signs that patterns of systemic oppression of women and girls would continue in the post-Cold War era. And then the book speaks about feminism, particularly in the context of international law. And she quotes Professor Sandra Friedman, very distinguished professor at Oxford, that what does ultimately feminism mean in the context of constitutional or international jurisprudence? And it means four things. First, the redress of disadvantage, which may require redistributive measures. Second, recognition of the prejudice, stereotyping, and violence that are caused by inequality. The third aspect is ensuring the participation of people in decisions that affect them. And fourth, the achievement of structural or transformative change, which is the fourth dimension of equality. I mention these four because we as judges and lawyers are constantly grappling with these ideas, not only in the context of feminist jurisprudence, but in terms of justice to our own marginalized, whether it's the scheduled castes, the scheduled tribes, the other backward classes, and so many other groups in our society. Therefore, from that perspective, I must, at the end, share that the first woman to be elected to the International Court of Justice was Dame Rosalind Higgins, who was also the first female president of the court. Judge Charlesworth is regarded as one of the pioneers of the feminist approach to international law and has brought this school of thought into the mainstream. She was the fifth woman to serve. She is the fifth woman to serve on the ICJ in the court's 77-year history. Recently, Judge Julia Sebutinde, the first African woman to sit on the ICJ, has been elected as the vice president. To have more women as judges of the ICJ is not the responsibility of the court alone, but a share of the responsibility must be borne by nation states and national groups who are responsible for the nomination process. I dare say the same in regard to the appointment of more women into judicial offices in India as well. I was reading that in October last year, the ICJ amended, among other documents, its rules of courts and practice directions to make their provisions gender inclusive. The Supreme Court of India has also made strides in this regard. The Supreme Court released a sensitization module for the judiciary on the LGBTQIA+ community, which seeks to sensitize members of the judiciary on concepts of gender and sexual diversity, on the usage of appropriate terminologies, and make recommendations on the protocol to be followed by courts while interacting with the members of the queer community. Similarly, the Supreme Court recently released a handbook to combat gender stereotypes in an attempt to ensure that judges use inclusive language and consciously avoid the use of stereotypes in decision-making. Before 2024, only 12 women had been bestowed with the title of senior advocate throughout the entire history of the Supreme Court. However, recently, there was a significant shift as the Supreme Court designated an equal number of women hailing from various regions across the country as senior advocates. They will be the torchbearers of change in the future of the legal profession in our society. There was once a notion of law which limited us to merely an isolated arena from society. Today, legal fora across the globe are recognizing that they cannot view themselves as divorced from the socio-political realities and aspirations of the time. This recognition fosters an environment conducive to mutual learning and exchange of ideas. I'm hopeful that the lawyers and researchers whom we mentor today, and so many of our law researchers are part of the audience, are going to change the way the legal systems have been working. The new generation of lawyers and scholars are evolving new paradigms to reimagine the conceptions of law and justice. I'm optimistic that the interaction with Judge Charlesworth will not only benefit the Supreme Court of India to learn from and engage with the International Court of Justice in the years ahead, but will inspire the young minds in the audience to reflect on finding solutions to the numerous challenges affecting the globe and our time. I once again extend my gratitude to Judge Charlesworth for gracing the Supreme Court of India with her presence, and I warmly welcome her to India And now I yield the floor to her for the highly anticipated lecture. Thank you.
She will announce here.
Thank you, sir. Your address was indeed a treasure trove of wisdom, garnered and gathered through experience and wide reading. With this, I request the Honorable Chief Justice, Dr. Justice D.Y. Chandrachud, to present a memento to our esteemed Chief Guest. It is time now to hear our Chief Guest for the day, Her Excellency Ms. Hilary Charlesworth, whose exceptional body of work in the areas of international human rights and international humanitarian law, feminist legal theory, and gender equality has not only shaped the academic discourse, but also shed light on the complexities and nuances of myriad forms of discrimination. Through her work, she has challenged the deeply ingrained societal norms and highlighted the urgent need for transformational change by dismantling oppressive structures. Through her work, she has opened places of inclusivity and empowerment. With this, I request our erudite Chief Guest to kindly address this august gathering, who are so eager to hear from her.
Chief Justice, Attorney General, Solicitor General, very distinguished former and present judges of the Supreme Court and of judges from across India, dear guests, dear colleagues, dear students, dear friends. Ma bahut hi khush मैं बहुत ही खुश हूँ कि आज मुझे यहाँ आमंत्रित किया गया है. It's indeed a really great honour to have been invited to deliver this second lecture to celebrate, to mark the anniversary of the foundation of the Supreme Court of India. And I'm very conscious that this is the launch of the 75th anniversary year. And I'm very, very grateful to the Chief Justice, Dhananjaya Chandrachud, for the invitation. As he's already told you, we met 40 years ago as students at Harvard Law School, and I still recall us nervously sitting together in Professor Tribe's course on American constitutional law, and we were both terrified that he would call on us impromptu. And this was a very bonding experience, but we spent these wonderful years at Harvard together exploring all the richness of that wonderful institution. So you will not be surprised that the Chief Justice stood out even then as an absolutely brilliant, but also, for me more important, a very generous person. And allow me to say that my family and I have deeply valued our friendship with him and his family over the years, and we hope it will continue to the next generations. Allow me also at the start to thank the staff of the court and the registry for graciously making all the arrangements for my visit. As you can tell perhaps, I've long had a fascination with India after studying Indian art and history at university. And then as a student, as you've heard, I did spend a year teaching, you'll be perhaps a bit shocked to hear, geography and hockey, of all things, at Mayo College in Ajmer. But exploring India that first year, that was my first visit, and I was here that year and had a chance to travel a lot, was really a profoundly life-changing experience for me, and I've visited a number of times since. And I have to say, it's just wonderful to be back here in this vibrant country. I have been wondering since I received this invitation what thoughts I can offer this very distinguished audience. And I did have the good fortune of reading last year's speech by the Chief Justice of Singapore and noting that he was able to draw on his long experience to distill lessons for fellow members of the judiciary. So I hope, given that I can't give you many lessons from my long career as a judge, that instead it might be of interest if I gave you a picture of the world of international judicial institutions, particularly focusing on the one that I joined just 2 years ago. I know, of course, that over the years the Supreme Court of India has manifested an interest in the work of the International Court of Justice. Unlike many other constitutions, the Indian Constitution acknowledges the role of international law in Article 51, part of the Directive Principles of State Policy. And the Supreme Court of India has, of course, regularly referred to international law and indeed on occasions to decisions of the International Court of Justice. Indeed, I've been struck that it appears much more open to invoking international law than other apex courts, such as my own, the High Court of Australia or the United States Supreme Court. But what I would like to do today is to start with describing the history and structure of the International Court of Justice. And then I want to discuss how it navigates its role as a legal institution in deeply divided political environments that implicate questions of judicial independence. Of course, the International Court of Justice's structure and jurisdiction are quite different to those of a national court, such as the Supreme Court of India, but I hope that you will find nevertheless that some of our experiences resonate with you. Well, the origins of the court, and this is our modern court building today, date back to the early part of the 20th century. And you can see here an image of the Hague Peace Conference, of the participants at the Hague Peace Conference of 1899, gathered on the steps of what's now the royal residence, the Haus ten Bosch, just outside The Hague. So there were two Hague Peace Conferences, 1899 and 1907, both strikingly initiated by Tsar Nicholas II of Russia. And those two conferences together resulted in the establishment of an institutional structure for international arbitration. And this is the Permanent Court of Arbitration, which is still going strong today. But an arbitral court is not a judicial institution, and there were moves in the early 20th century to create an international judicial tribunal, but these ideas only came to fruition after the First World War. And indeed, the Covenant of the League of Nations of 1919 precisely envisaged the establishment of what was called the Permanent Court of International Justice. And this permanent court was housed in the same building, the Peace Palace, or in The Hague. And I've got, this is a picture here of the inauguration of that building, and perhaps in the front with the white beard you can see the funder of the Peace Palace, the Scottish-American philanthropist Andrew Carnegie, on the opening day. So the first occupant was the Permanent Court of Arbitration, but it was then forced to provide half of the building for the Permanent Court of International Justice. So the Permanent Court was inaugurated in 1922, and indeed in that year it dealt with 3 requests for advisory opinions that had come from the Council of the League of Nations. In its life, between 1923 and 1940, the Permanent Court delivered judgments in 29 cases between states, and it rendered 27 advisory opinions. And its last public sitting was in 1939, just after the outbreak of the Second World War. And this is an image of formerly the last meeting of the Permanent Court of International Justice, which took place because of the war, because at that time, of course, the Netherlands was occupied. This is the image of the court, as it were, disbanding itself in 1945. I should say some of those judges immediately became judges of the successor court, the International Court of Justice. So the new court, the International Court of Justice, which was established under the Charter of the United Nations, we inherited a statute almost identical to that of the Permanent Court and adopted remarkably similar rules of procedure. And even today, our court operates under rules of procedure, many of which were first devised in 1922. The International Court, however, distinct from the Permanent Court of International Justice, was elevated to the status of a principal organ of the United Nations, institutionally on the same level as the UN Security Council and the General Assembly. Well, as for our structure, this is the opening of the International Court of Justice, the first hearing, and perhaps in the front row of the audience you can see the then young Crown Princess Juliana of the Netherlands, who went on to be, of course, a long-standing Queen of the Netherlands. And you can see the inaugural judges gathered round the table there. Well, this is the latest, what we call the family photo. I should say that the court, we had a new composition starting just on Tuesday. So this is the court in its composition as of last Monday. But as of Tuesday, of course, we lost 4 of our colleagues, including our President, Judge Joan Donoghue, and our Vice President, Judge Kirill Gevorgyan. But this shows you the one photo I could find of all the judges, all the old composition of the court together. So the court is composed of 15 judges who are required to be of different nationalities. And judges are elected by the United Nations General Assembly and the United Nations Security Council, voting simultaneously. And judges are elected for 9-year terms, which are renewable. The court's statute, and I quote from it, mandates representation of the main forms of civilization and of the principal legal systems of the world in the court as a whole. And how that's translated in practice is that requirement is observed in an informal regional allocation of the 15 seats. There has also been a tradition that the 5 permanent members of the Security Council always have a national on the court. This was so until 6 years ago, when the United Kingdom famously, I think I don't need to remind Indians, lost its seat on the court, and in the most recent judicial elections in November last year, Russia, as it were, lost its seat on the court. So there are 3 permanent members of the Security Council still have judges on the court. So we can't really refer to that as a long-standing tradition anymore. The statute doesn't refer to gender representation, unlike, for example, the Rome Statute of the International Criminal Court. And I think overall the International Court of Justice has a poor record in attention to gender balance. In almost 8 decades, just 6 women have been elected to the court, while 109 men have been elected at the same time. Today, with our President Joan Donoghue has been the new American judge, Professor Sarah Cleveland, has joined us. So we are still 4 women and 11 men. You will be aware that a former member of the Supreme Court of India, Judge Dalvir Bhandari, we call him judge at the court. I'm aware that he would be justice here, but he's Judge Bhandari at the moment, is a current member of the court. Other distinguished judges from India include B.N. Rao, one of the architects, I need not tell you, of the Indian Constitution. He was elected to the court in late 1951, but sadly died before he even completed 2 years in office. Perhaps the longest-serving Indian jurist that we've had on the court is Judge Nagendra Singh, who sat on the court for 15 years. In the 1970s and 80s. And he also served as the court's vice president and then president. And as president, he presided over perhaps one of the most significant cases in the court's history, the Nicaragua case, and I'll come back to that case. Every day I walk past this statue of Nagendra Singh, Judge Nagendra Singh, because if you're president at the court, you are allowed to choose either a sculpture or a portrait. And so the sculptures are displayed in the judge's wings. So I feel, although of course I never knew him, but I feel I see Judge Nagendra Singh every day with this splendid bronze portrait. Another Indian judge on the court, Raghunandan Swarup Pathak, who was appointed when he was elected to the court when he was Chief Justice of the Supreme Court, and he finished Nagendra Singh after Nagendra Singh's death in 1988. The court invariably sits with all of its 15 members. The statute of the court, it's true, contemplates the formation of specialist chambers to hear particular cases, but that clause has, surprising to me, it's been very, very rarely invoked. It's at the discretion of parties to call on the court to constitute a smaller bench. So almost invariably, we sit in the composition of all 15 judges. If there's no judge of the nationality of a state party to a dispute on the bench, that state may appoint a judge ad hoc for that case. So in some cases, we have 16 or even 17 judges. In 3 out of the 6 cases involving India during the court's 8 decades, there was no Indian judge already on the bench, and so various distinguished Indian jurists were appointed as judges ad hoc. So one was the former Chief Justice of the Bombay High Court, M.C. Chagla, who was ad hoc judge in the Rights of Passage case, the case brought by Portugal against India in the late 1950s. Judge Nagendra Singh, he was also, before his election to the bench, he served as judge ad hoc in a case India brought against Pakistan relating to the jurisdiction of the ICAO Council. And Supreme Court Justice B.P. Jeevan Reddy was appointed ad hoc judge in a case that Pakistan brought against India, the aerial incident of the 10th of August 1999. So that's the membership of the court. What about jurisdiction? In its contentious jurisdiction, the court deals only with disputes between states. So unlike the International Criminal Court, we never see individuals as such in the court. They are never before us as individuals in the court. All 193 members of the United Nations are automatically parties to the court statute, but that doesn't necessarily mean that they accept the court's jurisdiction. There was some discussion whether the court should have compulsory jurisdiction during the drafting of the UN Charter at the San Francisco Conference in 1945. And that position, the court having compulsory jurisdiction, was certainly championed by smaller states such as Australia and New Zealand. But ultimately, the view of the United States, the Soviet Union, and the United Kingdom prevailed, and that was that jurisdiction should be voluntary, and that's the situation today. So there are 3 distinct ways by which cases can come before the court. First of all, it's possible for states to enter into a special agreement to submit a dispute to the court. And we have a nice example of one such case currently on our docket, and this is where the Caribbean coast neighbours of Guatemala and Belize have agreed to submit a territorial dispute to the court. So that's one route, and that's in fact the easiest route because one knows there will be no challenges to jurisdiction or admissibility. But a second route is when both states are parties to a treaty that grants the court jurisdiction to decide disputes between treaty parties. And examples of such treaties that have such a jurisdictional clause include the Genocide Convention, and of course it was precisely Article 9 of the Genocide Convention that was invoked by South Africa in its recent case against Israel. There is the Convention on the Elimination of Racial Discrimination that also has a jurisdictional clause, the Convention on the Elimination of All Forms of Discrimination against Women, and the Convention Against Torture.